there anything worse than ongoing high conflict litigation in a divorce process? Probably not. In fact, divorces rank as one of the most stressful top 5 situations that a person will ever have to go through. Add on that you are in a high conflict, very litigious situation, and maybe it tops the list. That's why so many people try and stay out of court when they go through a divorce. You hear so many discussions about the benefits of mediation, alternative dispute resolution, and just overall settlement in a divorce. That's what we're going to be talking about today. We're going to talk about all of the ways to navigate and successfully negotiate a mediation settlement and get through the mediation process with the goal, fingers crossed, of reaching an agreement and ending the divorce battle. Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of family law, estate conflicts, inheritance disputes, all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue? Let's begin. Gavels down, voices up. In today's episode, we're going to go over the strategies for mediation, some tips and tricks, and one of the things that I learned in law school that holds true in 100% of my cases. All right, let's get into mediation and divorce. Mediation in a divorce can be at the beginning of the divorce process, or it can be somewhere in the middle. There are many people, many couples that are able to start mediation right at the beginning. They are getting along to the extent that a couple does get along through a divorce process. They agree that an amicable divorce is the best for both of them, and they're more aligned when it comes to how to divide and separate than they are in dispute. That doesn't mean they agree on everything, but they do understand that there are going to be certain things that are going to have to be conceded. And so they go in and they are able to handle a mediation right out the gate. For other people, we're just not quite ready, whether it's you that isn't ready or other party spouse that isn't ready. And it can take some time, some emotional healing, some incredibly expensive attorney's fees, delays, court processes, all of the things, maybe even meeting a new significant other and wanting to get hitched, that can force somebody to be finally ready for mediation. In a very small number of cases, they actually go to trial, but it's shocking that for as many cases as they are, really only about 5% end up going all the way through the trial process. So chances are, if you are involved in a divorce process or even arguably a family law situation, you are more likely to end in settlement than not. That's why this is so important, because if you know that you're more likely to end in settlement, 95% likely to reach some kind of agreement, you want to have the tools to reach the best agreement you can as early as possible. The first thing I like to tell people, and this is what I learned in law school, this is a piece of gold nugget information when it comes to mediation. And it holds true not just in divorce cases, but in every single case that I've ever been involved in and litigated. Truly, 100% of the time, I have two people want separate things. It can seem on the surface that you're both fighting over the same issues, but really, when it comes down to it, if you take the time, you'll realize that this whole pie that we've got one whole pie. And the slice that you want is different than the slice that the other party wants. And that's true in divorce. I have never had a case where both spouses were fighting over the same piece of pie. When we are going into mediation, understanding that your piece of pie is going to be different than their piece of pie. And so it's really just about how you can get your slice, they can get theirs, and the rest of it, we can divide equally. Now, what is the piece of pie? Let's consider the piece of pie your deal breakers. This is the thing, and I say keep it to 1 or 2, maybe 3, things that no matter what, you are not going to concede them. And then as we look at what the piece of pie, the deal breakers are, we need to compare them to the law. So you want your deal breakers to be reasonable deal breakers under the law. And this is what I mean. I once had a client who said that their deal breaker was getting sole custody of their children. Now, maybe this works for some people if you have an abusive ex or other parent who is going to drop off the face of the earth and doesn't really seem to be so invested in children. That might be possible. In my client's case, that wasn't possible. Other parent wanted to be involved, wanted to have some kind of relationship, maybe didn't want to be an equal parent as far as timeshare, but really did want to make sure that they maintained a relationship with their kids. So when my client walked in and said that the deal breaker was getting sole legal, sole physical custody, I had to break it to her and really, really work through the fact that that probably wasn't a practical deal breaker. We want deal breakers to be practical. Now, what was a practical deal breaker is that she was the primary parent for the purposes of raising the children. She had the most time with the kids. The kids lived at her house primarily. They went to school based on her location. And for all intents and purposes, she really was the main parent, but not to the extent that it rid other parent of their rights, their opportunities, and even visitation. So when you're looking at what your deal breaker is, you want to be clear, write it down, but you also want to see, is this a sword that you're willing to die on? Or another way to look at it is going to trial. If you take it all the way, you're that 5% that goes to trial. Can you win it? If you can't win it, then your deal breaker is not practical, it's not plausible, and you need to adjust it slightly. But still, you want to make sure that you identify your deal breakers and you want to identify them prior to going into mediation. How do you figure out what your deal breakers are, right? We're looking for your piece of the pie, and it's a piece. It's not the whole thing. It's not even half, all right? So 1 to 3, and you're going to sit down and reflect on what matters to you, what truly matters to you. Are you like my client that wanted to be the primary parent for custody and raising of the children? Is paying spousal support something that you really don't want to do, like almost anything else? You just are not going to be willing to pay spousal support on a monthly basis for any extended period of time. Maybe you really want to stay in the house, the marital house. Maybe staying there is really important to you. Maybe having ongoing spousal support is really important to you because you don't really have a career and you think that's the only way that you're going to be able to survive. Maybe saving your retirement all for yourself is really, really important to you. Or I've represented police officers and firefighters in deferred comp. Big one. They really wanted to maintain their deferred comp all the way for them. So what really matters? Take some time and do some self-reflection to identify the things that really, really matter to you. What would you be willing to go all the way to trial for? All right, now that we know, again, what you've been able to go all the way to trial for, I say keep them at 1 to 3 ultimately. But for the purposes of the first part, this first step, just identifying what's important, you want to have as many as you need, 5, 10, 15, it doesn't matter. What is really important to you? Write them down. Are you willing to go to trial? If you're willing to go to trial, then put an asterisk next to it because we know that's important. Then you're going to rank all of these ideas. Whether you only have 3 or you've written down 50 things, rank them as most important. We want to know really what is going to get at you. Remember, these are deal breakers. Then we're going to consider the future implications, long-term effects of each goal. Maybe you write down and you rank being the primary parent as one of your top 3. But now you're sitting back and you're like, but I also really want to work on my career. I want to get a job that I'm going to travel in. Is it practical long term for me to be the primary parent? Or should I really work on figuring out a relationship between our children and other parents so we can have more of an equal timeshare situation? How is this going to affect you long term? If staying in the house was your number one, that is what is most important to you. Are long term you going to be able to pay for the house? I once had a client whose number one deal breaker was to maintain the occupancy of the house. She really wanted to stay in the house. Well, that's great, but at some point she's going to become solely financially responsible for this house. And the bottom line is that when we looked at all of the picture, long term, The fact that she was not going to be getting the spousal support that would support this house, and the ability to work, and simply the cost of the house. We're talking property taxes, maintenance of the property, air conditioning of the property, things that aren't going to go away. She really couldn't afford it after about 2 to 3 years. So is it worth fighting over having your number one goal being keeping the house if you're not even able to maintain it long term? I don't know. We might need to restructure and regroup, and maybe that moves down a little bit farther. So again, you're going to reflect and figure out however many top priorities you have. Then you're going to rank them the most important. And then you're going to analyze your top 10 and say, how is this going to affect me long term? Is it practical long term, given what my life is about to become and what I'm going to be looking at moving forward? If it's not, that's okay. That's why we're doing this exercise before mediation, and readjust your numbering. And then you want to be able to make sure that you can clearly explain your goal. If your goal is to stay in the house all the way until your youngest child graduates, you want to say that. But what does that mean? My goal is to be able to maintain the marital property all the way up until our youngest child graduates, plus 6 months, after which I will sell it or refinance it. I do not want to have to buy out other party at today's value. I just want to be able to do it at future value. I'd also like to have all of the costs split. Whatever it is that your number one goal is and how it's going to play out, you want to be able to clearly define it, clearly talk about it, so that you can explain it to a mediator. The mediator then will use that information to try and see if an agreement can be tailored that gets you your deal breaker. So take some time and really think through it. I practice in the shower. You can too. Now we have our goals, right? We have our deal breakers, our top 3. That's what's going to end up being your deal breakers. And then we have everything else. I consider everything else like fringe. If you get anything after 3, that is great. Then you have done very well. Otherwise, the rest of them, 4 through however many, they just need to go. As long as you can live with it, that's probably what's going to happen. Nobody in mediation or at trial is going to get everything they want. But let's talk about some of the benefits of mediation. One, you're in control because you just made a list of your top 3, and you're probably going to get one of them because no 2 people are after the same piece of pie. So chances are your number one is different than their number one, and you're both going to get to walk away with your slice of pie. You're not going to get everything, but you're probably going to get your number one. That doesn't happen in trial. In trial, the judge isn't trying to make you get what you want and spouse get what they want. They're just trying to divide everything according to the law. So if your number one was to stay in that house, guess what? The court doesn't care. The court is going to say that's a marital house. I want it sold and the profits divided equally. So the biggest benefit to mediation is that you are in control of the agreement, and you will get one of your deal breakers. Everybody does. The other benefits of mediation are maybe some of the things that you've already considered. It's cost effective. If you can reach an agreement on one or all of the issues sooner rather than later, you are going to save yourself the emotional cost and the financial cost of ongoing litigation. Even if you mediate partway through or the day before trial, in every single case, you are saving financially. One, you're saving the costs of the attorneys or the time that you have to take off work because court is during work hours, or you're saving yourself the emotional stress. And don't think for a second that the emotional stress isn't a cost to you in your divorce. It absolutely is. And emotional stamina needs to be weighed just as important or equal to the financial benefits or drawbacks in a divorce process. So a mediation will be more cost effective. It will save you financially, and it will save you the emotional tolls of a divorce. This is important because if you go into mediation, I can't tell you how many times I've had somebody say, I'm not going to pay $1 more than 1,000. Okay. And I'm like, all right, that's fine. And then we get to 1,005 and they're like, no, I said $1,000. All right. Well, financially, it might cost you more than that extra $5 to get your case all the way to trial. Then you might lose. And lastly, you might be out way more than that $5 when it comes to the attorney's fees and everything that goes into it. So instead of having fixed numbers, you really want to be aware of what's going on and weigh all of the financial and emotional cost as you're going into mediation, because mediation and agreements save that. Second, mediation is less adversarial. Yes, you might have attorneys present, maybe you don't, but the goal of mediation is really to come together and to reach an agreement on one or all of the issues and make it so that you and other party both get their number one. Let's take a quick break. If you're navigating the twists and turns of divorce, you might be wondering, getting divorced, now what? That's actually the title of my upcoming book, designed to guide you through the challenging and emotional process of divorce. It's packed with real-life stories, expert tips, and motivational insights to empower you every step of the way. While it's not available just yet, you can join the waitlist to make sure you don't miss out. Head over to rachelkingattorney.com to sign up to be the first to get a copy and enter to win a free signed copy as soon as it releases. Arm yourself with the knowledge to move forward confidently through this challenging time. Now let's get back to the show. All right, if you are the person sitting here saying, no, they do not deserve their number one because they've been horrible to me, okay, but that's really a you issue, and you probably need to deal with that. You're not coming at it from a non-emotional standpoint, and we'll talk about that in a moment. Mediations are confidential, and this is one of the real benefits to mediation. If you come into court, you are both posturing to have the judge rule in your favor. So you're not willing, in most cases, to concede issues or to even admit anything that could be used against you later. In mediation, you can. In mediation, it's okay to say, oh, I really want the house. I want the house so much. I'm willing to give up the retirement and the spousal support as long as I can get the house. Well, you would never say that in court, right? Because that could be used against you. Why would you be willing to waive retirement? Or why did you do something wrong? You can say it in mediation, because everything that you say in mediation is confidential, meaning it's not going to be used or brought up to the judge. It can't. As soon as somebody tries to bring up mediation in court, the judge is going to say, no, I'm sorry, settlement discussions I'm not to hear them. So you have the freedom to be a little bit more open with your wants, your concerns, your needs, your wishes, all of it, to be able to reach an agreement that satisfies both people. You don't have to worry about it being used against you later because it's not coming out. The last thing, and I think this is one of the reasons that mediation can be so successful, is in mediation, we can be really flexible. Within court and trial, the judge can't be so flexible. There's rules, there's laws that they have to comply with. In mediation, that's not the case. So let's talk about that house situation. Again, my client really wanted to stay in the house. It was so important for my client to stay in the house until the youngest child graduated high school. The judge wouldn't have had that flexibility. The judge would have had to say, nope, house is sold, because spouse really did want the money out of the house now. Thought, this is not my problem. I want the money now, and I want to be off of that loan. So a judge would have just done that because they're restricted to the confines of the law. As we were reaching agreements and trying and mediating this case, one of the agreements that we were able to reach, which was so amazing because, again, that was my client's deal breaker, is you can stay in the house right now. You have to pay the mortgage. You have to maintain the property. You can live there until the youngest graduates or plus 6 months, at which point, if you still want to stay there, we're going to get an appraisal. The appraised amount will be the amount to refi. We'll deduct out the mortgage, divide by 2, and that is how much you buy out your spouse for through a refinance. If, on the other hand, that 6-month time period comes, you decide you don't want to maintain the house, or you can't afford it, or refi, or whatever the case may be, no worries. House is put on the market, both of it's sold, and the proceeds are divided. Well, in that case, spouse was totally in agreement. Why? Because spouse ultimately just didn't want to be on the financial hook or liability of this. So as we were presenting this and reaching this agreement and discussing it, not only was my client free to be a little bit more open and raise the concerns and say, look, our kids are in high school. If we don't keep this house, then They might have to change high school and it's really for them. So that was appealing to other spouse because good parent. And then we were able to reach this agreement based on the fact that spouse was going to be realizing all of that increased equity through but not having to pay any of the mortgage. So it was going to be a gain. And then the little caveat that we added in was if the house took a loss, that was going to be realized by my client. So there was really nothing for spouse to lose except the fact that they were going to be on this mortgage up until that happened. We also added in clauses about if the mortgage wasn't paid, what would happen then? So reaching an agreement was possible because of the huge amount of flexibility that we have when we're drafting our own agreements. When you're reaching out and you're talking and you're being more open, all of that is possible in mediation. None of it is possible without a stipulation. Now, you may be saying, oh, Rachel, but I was in court and I heard a judge make some kind of nuanced, weird, kind of not by the book order. Yes. You know when that happens? When the judge says, do you guys stipulate? Do you agree to it? If you agree to it in court in front of a judge, sure, the judge will make that order based on the agreement. That's the same thing as mediation. You're just doing the agreement in front of the judge. The goal for mediation is to do it before you get to the judge so that you can take away that stress, you can maintain your control, and hopefully reduce some of your emotional costs and your financial costs. Now we've prepared for mediation. We know what we're going to do. We're going to speak clearly. We have all of our most important deal breakers, and we know why we're going into mediation. So what do you do on the day of? How do you prepare for it as you're walking in? One, you want to have all of your documentation ready. There's nothing worse than saying, I want the house and I think the house is worth $500,000 and I want spousal support and I only make $1,000 per month, but you have no financial backing, you or no proof. You don't have an appraisal and you don't have your pay stubs. You want to have everything together. In fact, when I talk to clients, I say for mediation, we're going to prepare for it sort of like we're putting on a trial. We're going to have everything we need to tell our story and to support it. While the goal in mediation is slightly different than the goal in trial, we're going to have all of the information available so that we can show the mediator why our top three, our deal breakers, are really important and how it's possible to have them created. We're also going to have all of this other information for all of the other issues so that as we're talking through this, maybe we don't get exactly what we want, but we're getting some kind of agreement. The worst thing that can happen in mediation, which has happened to one of my clients, is they didn't have any of the documentation ready. They didn't want to spend the money to get the appraisal or to have the analysis for custody and visitation. They wanted to just go in off the cuff and save as much money and fingers crossed that the other party was willing to agree. But here's the problem. Other party wasn't willing to agree before mediation because they didn't have any information. So my client sitting in the mediation saying, well, this is what I want, it just didn't get anywhere. Other party was like, well, but show me that that makes financial sense. I disagree with you on the value of the house. I think it's only $100,000. Now we're just circling and we've wasted money. So when you're going into mediation, you want to make sure that you have not only your goals, but all of your supporting documentation to justify why what you want is an appropriate thing and possible. Next, focus on your facts. This is similar to court. You have a fixed amount of time and you're paying professionals, whether you have your attorney there or you're paying a mediator. You have professionals there that you are paying on an hourly basis or lump sum to handle your mediation. You don't want to waste time rehashing how horrible it is that your ex cheated on you. Got it. It's horrible. It's really good that you are getting divorced, but it's not what a mediator should be discussing. Why? Because there's no penalty for adultery in California, for example. Now that might be different in other areas, but you get my point. You don't want to bog down or waste time on things that really aren't going to impact your mediation or your ultimate settlement. So stick to the facts. Stick to that list of goals. Stick to why it works. Stick to your supporting evidence. Stick to that. Take all of the emotions, though I get that they're important, outside of court and complain to your friends, your family, your support system, even your therapist. And if you really have money to blow, call your attorney and keep him on the line for an hour talking about your feelings and how sad you are that you're getting divorced. I say this a bit in jest. It happens all the time, but gosh, I want to tell my clients, and I do tell them, it's really expensive to keep me on the phone and just bitch about your ex. You can bitch about your ex for free to a whole bunch of people. But you know what? If you want to pay me my hourly rate to bitch about your ex, I will listen. All right. We're going to stick to the facts because that's time well spent in mediation, and we're going to ask for breaks. If you feel like you're getting out of control, it's getting a little emotional, it's hot in here, you're like, I'm getting off topic, I can't focus, everything that the other person is saying is really getting to me, take a break. It's okay to take breaks. Now, you don't want to take half an hour breaks every hour because that's a waste of time, but you do want to take breaks as necessary. It's so important to take breaks in mediation because as the tensions rise, as your emotions may get out of control, you want to step away so you can get everything back in line and balanced so you can make a decision that's going to work best for you long term. In mediation and in trial, we are not trying to make emotional decisions. That's really hard when you're talking about a family law situation, custody, visitation, finances, what life is going to look like outside of marriage. But if you can make them with a little bit of emotion removed, then it's going to be better for you. Most clients that I deal with will say that if they enter into a mediation or any agreement and they've made it sort of from a methodical, analytical standpoint, men and women alike, they are more comfortable with it days after. The clients that I've had that have made very emotional decisions in mediation, whether that's to reach the agreement or say, screw it and blow the whole thing up, I'm not going to reach the agreement based on emotion, they're the ones that come back and say, oh, that was like a really bad idea. I shouldn't have done it. So if you need to take breaks so that you can make those rash decisions free of emotion, do it. It's going to be better for you. You can bring somebody to mediation. You can bring a therapist, you can bring a support system, you can bring an attorney, you can bring somebody. Now, I have mixed feelings about this from an attorney standpoint. On one hand, yes, you want to have the support of somebody that's there, but you don't necessarily want to have your cheerleader friend that's always got your back no matter what, your ride or die that's going to say, yes, let's go down, do it together. That's maybe not the best person to take with you to mediation. Having a friend that's willing to tell you when you're wrong, when you are wrong, that's willing to say, hey, I get that you don't think this is going to work right now, but long term, this is going to benefit. That's the friend that you want to bring. Or even better, try and bring somebody who isn't going to weigh in on your decisions, but instead is going to help you make a decision. Some of the biggest pitfalls that people have had that I've witnessed through mediation is that they bring a highly emotional, for example, parent to their divorce mediation. Now, parent, of course, loves you with all of their heart. They want you to be the best version that you can be, and they're ready to go to the death against anybody that wrongs their child. I got it. That's maybe not the best person to bring to mediation because as soon as you are willing to concede an issue for the benefit of other party, but because it's going to get you something, a really emotional cheerleader friend or parent isn't going to be able to say yes. In fact, sometimes they'll talk you out of it. So be really aware of who you bring. And many times I, as an attorney, will say, hey, let's have the emotional support system. Let's have anybody who might interfere with the mediation. They can come, but let's have them sit out of the room. We don't necessarily want them involved if they're going to cause more problems than they're going to solve. So please, if you're going to bring an emotional support person or somebody to help you get through it, be aware and think through this person and whether you want them to be involved in decisions that are going to affect the rest of your life. Maybe they're a really good pal to have a glass of wine with and watch Hallmark movies with on a Saturday night when your kids are with other parents, but maybe they're not the best for deciding what your financial future is going to look like because of divorce. The next thing we're going to talk about is mindfulness. And actually, this can be used with trial as well, or any in-court appearances. These are really stressful proceedings. Not only are you in a room most often, sometimes you're in a Zoom with the other party who you once loved and now you are not going to maintain a life journey with them. That's hard enough. You're dividing your family, you're dividing your finances, and you're losing your dream. And the amount of emotions can really be incredibly high. Add on that most spouses know how to get under the skin of their partner immediately. And as the tensions rise in a mediation or any kind of communication or court proceeding, it can be really easy to just make that dig, take that jab. You know that you can do it for your spouse. You know that you can take them from 0 to 30 immediately. You also know that they can do it to you. Why do you know that? Because I'm telling you they can. I love my husband, but man, I could piss him off right away. He could walk in the door right now and I would know exactly what to say that would blow him up. And the bottom line is that we have a tendency to do that subconsciously or consciously when we get upset, emotionally stressed in these kind of mediation or court proceedings. So here's what you need to do as you are in the mediation or again, the court proceeding. Think about what you're going to do or how you're going to handle the stress. Taking deep breaths can be really helpful. Doodling can be really helpful. Focusing on putting your hand on the table or your foot flat on the floor and just noticing the way the hand feels against the table or the foot feels against the floor can be really grounding. All of these can take your mind off of what is happening immediately and give your body and your mind a chance to come inside, regroup, and pause. And that is going to be very important. You can do these techniques while you're actively participating in mediation, or you can do them in the bathroom or on a break. But in any case, you want to have a plan for what you're going to do when you get overly stressed or your ex just gives you that jab that you weren't expecting because you came in good faith and they came in pissed off. What are you going to do and how are you going to handle it? So again, you can maximize the benefits of mediation because all we're doing in mediation is trying to have you have the best outcome of possible. So put yourself first. How are you going to maximize your benefit? Lastly, you want to make sure that through the entire mediation process, you maintain your goals. You'll know this because when you walk into mediation, since you prepared, you will have your top 3 deal breakers all on the top of a plain brand new legal pad, starred so that you can see them in big writing. Under that, on your brand new legal pad, you'll have all of the rest of the issues and your general ideas of what you want. I say on this brand new legal pad for each issue, have your best case scenario if you got exactly what you want and maybe what you would be willing to settle with. And go into mediation open-minded. Don't have these fixed guidelines. Yes, you want to have a general idea of what is acceptable to you, but I don't think it's ever a good idea to have hard and fast lines because then as soon as you go 1 centimeter over in each direction, you're throwing in the towel. And you shouldn't be throwing in the towel at any mediation if you guys are both slowly coming together. Even if you're coming together $1 at a time on counteroffer and counteroffer, or 1 step at a time, that's okay. You're moving slowly, slowly, slowly together to the center. And you want to get to the center on as many issues as you can, because if you reach the agreement in mediation, you don't have to risk the judge's decision and lose control. Try and reach agreements. But if you can't, that's what we have trial for. My biggest takeaway that I want everybody to know is if you reach agreements in mediation, you must formalize them in writing. Chances are that emotions are going to run high immediately after, and one of you or both of you will have a period of regret of making the decision or a period of stress, all of it. You want to make sure that the agreement is signed so that as you go through that emotional roller coaster afterwards, nobody's going back on it. If you get your deal breaker, you bet your butt you don't want the other party to come in tomorrow and be like, never mind, I take it back. And the same is true of them. So while you are in this mindset of mediation, you're practicing mediation, you're participating in it, and you're reaching agreements, take the additional time to formalize it in writing. Even if it's only 1 or 2 issues, formalize it in writing. I have been in mediation for 12 plus hours. The sun has set. I've had to put my kids to bed. I've taken a dinner break to go wash my face, and everybody comes back to the Zoom meeting exhausted and in PJs, and yet we're still doing mediation. Those are long, long days. And you know why I do it? Because once I've gotten the agreement, I need to make sure that before everybody signs off, I've had the signatures inked. So I'll take my break, I'll type up the agreement, we'll come back in PJs, we'll have everybody look at it, and we'll still sign it. These are for virtual, obviously, virtual mediations, but the same would be true in person. You want to make sure that you sign it while you're at mediation. I can't tell you how many times I've had people reach agreements and then the next day they change their mind or other party changes their mind, and it implodes the entire case farther back than before mediation, because now there's a brand new breach of trust. It's like, well, we just agreed on this yesterday. You can't sign it today. Get the signatures during mediation. With all of these tips on mediation, I hope you're ready to go. I hope you're feeling more confident as you walk into settlement. Remember, it's all about you, maintaining your confidence, maintaining your control, and maintaining getting an agreement that you can live with for the rest of your life. A judge said, if you are unhappy with your result, then you probably did okay. Most people aren't going to be happy with their outcome in family law, whether that's through mediation or in court. But if you can be in control and you can live with it, that's going to be the best that you can do. And more than anything, you get to move on to the next step, the next phase of your life. You can close up this chapter and move on. And even though that can be really scary, I promise it's going to be better when you're there. Well-negotiated divorce can have amazing long-term effects for you. So don't rush mediation, be ready for it, prepare, and good luck. If you are negotiating your divorce or settlement, or you've done it before, I would love to hear your story. Please share the tips, tricks, or pitfalls that you found yourself in so we can all learn from you. My name's Rachel King, and if you have any questions, don't forget to reach out. Till next time. That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up, because every voice deserves to be heard.